Well, Nigerians are applauding the decision of the National Judicial Council to summon 3 judges to explain their conflicting ex parte orders over the same matter. While the summon and the Riot Act from the Chief Justice Tanko Muhammad to judges to stop unnecessary assumption of jurisdiction in matters already before another court is expected to protect the court from lawyers that are out for forum shopping and stop the abuse of court processes. While the Chief Justice also warned Chief Judges to stop making newly appointed judges vacation judges and assigning complex cases to inexperienced judges. The Chief Judges will now be held vicariously liable for misdeeds of judges under their authority. However, lawyers say the restriction on the issuance of ex parte orders should not be limited to political matters.
Well, for a clearer view on this legal issue, we're now joined by Professor Epiphany Azinge, a constitutional lawyer and former Director General of the Nigerian Institute of Advanced Legal Studies. Glad to have you join us in the studio.
Thank you very much. Glad to be here.
All right. Contrary to what is usually the norm, the NJC this time is by itself investigating 3 chief judges. How far-reaching can this be in tackling these anomalies?
Well, I believe this can be said to be the most proactive measure ever taken over a period of time. Mark you, we've been grappling with this anomaly for a very long time. Circumstances where judges issue some of these orders. It is important to situate things in proper context, namely to say that interlocutory orders are known to our jurisprudence and to our judicial process, so there's nothing fundamentally wrong with it. What obviously is the issue is when there is, so to speak, an abuse of that process, either for political reasons or otherwise, and that's where we feel that we have a problem. And obviously, we're all aware of the developments up and down the country, bordering on foreign shopping. And to that extent, if we allow things to linger, certainly we'll come to a stage where obviously the country can grind to a halt and our judicial process will become meaningless. So we applaud the fact that the Chief Justice of Nigeria at this point in time took this proactive measure. Firstly, to send a signal, a clear signal to the chief judges that it should not be business as usual. We note historically that one of the things that led to the demise, so to speak, of the interim government was this incessant ex parte orders here and there, and that led to the demise of that republic. So we cannot allow this again to destroy what we believe is part of our judicial foundation. So this is particularly impressive. But going further, we have to ask questions. We must draw a line somewhere. There must be a delicate balance so that it doesn't appear that the Chief Justice of Nigeria is now superintending or supervising other courts, so to speak. We have the independence of the judiciary, and it is far-reaching. To the extent that the Chief Judge of a state is autonomous to a very large extent. Well, inasmuch as we concede that acting as the chairman of the NJC, the Chief Justice of Nigeria in that capacity can wield the big stick, not in his capacity of the Chief Justice of Nigeria, but in his capacity as the chairman of the NJC. He can wield the big stick and try to call them to order. But having done that, my position is that having done that, I believe that by now, the National Judicial Institute should be putting out a program for retraining of some of the judges as far as this issue is concerned.
Is that what is missing then? And how much of a deterrent do you think the Chief Justice's intervention will be? Should the Chief Judges be held vicariously responsible for the actions or inactions of judges within their
I believe that it is a kind of calling them to order, telling them you must rise up to this responsibility. You notice that the issue is that we are on vacation, and during vacation we have vacation judges. The practice in most jurisdictions is that the youngest judge appointed is the vacation judge. Now, what the Chief Justice of Nigeria seemed to be saying is that, what does he know? How long has he been there? What experience is he bringing to the table? So he can do and undo, but nobody can hold him responsible. But you appointed him. You know his limitation. You know his inadequacies. So next time, considering the situation we found ourselves, make sure you appoint a much more experienced judge as a vacation judge, so that we will not be confronted with this anomaly, so to speak.
All right. The CJN says an end must be brought or put to ex parte orders occasioned by forum shopping. I want you to speak to the order on ending ex parte orders, and let's really understand this forum shopping and those responsible for it and how it can be stopped.
Well, the truth of the matter is that when, for instance, we have political matters, and what has confronted the judiciary in the present time is the issue of political matters, especially matters bordering on the chairmanship of the PDP, and so on and so forth.
And other parties.
And the other parties.
Including APC.
Yeah, and APC. Now, another will flow in from Port Harcourt. And then another order will come in from Kebbi. And before you settle down, a counter order is coming in from Cross River, and so on and so forth. It makes a mockery of the judicial process. But you ask yourself, what could be the allocutors, a kind of plea of those judges? Some of them may argue, and with a lot of benefit, that they never heard of the order from Port Harcourt or KB, as the case may be. They may argue, but not in present times, not with the social media, not with the internet, not with the avalanche of information on parade all over the country. But even at that, there should be a benefit to be given to them to an extent, in the sense that the judiciary should now be thinking of how to harmonize information flow, communication flow amongst the judicial arms, so that whatever is happening in one part of the country automatically will filter through to the other parts of the country, so that no judge can claim that he or she did not know what happened in Port Harcourt or what happened in KB.
But even in the law court, I mean, ignorance is not an excuse.
I wanted
but
him to,
he will
hold on,
definitely,
because let him just talk, because you've not addressed the issue of forum shopping. Who are those behind
responsible.
it?
Well,
and how do we stop it?
I know that generally the idea trying to be presented is that lawyers are responsible. The lawyers are the ones that will take the matter before the court to seek and apply for the ex parte order. But having done that, the final decision to be taken on such a matter is the judge. So lawyers are responsible, but lawyers are also acting as dictated by their clients. And who are their clients? Basically, we believe in some of these instances, mainly they are politicians. And these are political matters more often than not. What we are trying to argue against is that why should this resonate all the time whenever we have political crisis here and there?
Very important.
Automatically, the issue is go to court, get an order, and so on and so forth. There comes a time when the judiciary would say, no, we cannot be used in this process. There must be a stop to this abuse of the ex parte order.
Now that the CJN has summoned these three judges, of course he has not named them. I would like to know if that is the norm, or how does that affect, making them scapegoats if they are not known? And is it usual to not name erring judges? What exactly are the likely sanctions that the CJN can actually apply?
I believe, not speaking authoritatively on it, but I believe it is not important for some people to be used as scapegoats. So the NJC, they are trying to be very, very discreet in their approach, because naming is already to shame, and they don't want to adopt that approach. So ultimately, we get to know who they are, and also we will get to know what the final decision of the NJC is. But as it is now, it would appear that we are still giving them benefit of the doubt, no matter the trial process that will ensue.
If they are found to have come or fallen short, what are the options before the CJI?
Well, the disciplinary measures are there, but I wouldn't think that it will be something as drastic as anybody will think. A warning will suffice at this point in time. A warning, go and take charge of your courts as the chief judge. And then from there, know who you assign particular cases to.
Let me just drop this in 30 seconds before we let you go. The whole essence of this is to restore discipline and honor to the judiciary. But how will it impact the efforts or work of INEC, who at times are left in a quandary?
Well, I agree that occasionally the effect can snowball and it can be far-reaching, as the case may be in such circumstances. But the decision of the court is binding at all times, regardless. So that's why we should also be worried that it could well affect other arms of government in a way they discharge their mandate one way or the other. So we should be very careful not to rush into ex parte orders so that we don't impact negatively on other issues. But more significantly, my position is that for purposes of judicial integrity and for public perception of the way the judiciary carries on, and also to build up the confidence as far as judges are concerned, I believe we have to be very careful. And to that extent, I believe the Chief Justice of Nigeria has done the right thing at this point in time.
Thank you very much. Of course, every time a case is brought before the court is also in the dock. Thank you so much, Professor Epiphany Azinge, Senior Advocate of Nigeria.